mode until today's question and answer session. If you are dialed in through audio and your computer, please be sure to mute yourself so that we do not have an echo throughout the conference. I would like to inform all parties today's conference is being recorded, and if for any reason you object to that, you may disconnect at this time. I would like to now hand the conference over to Erna Hughes. Ms. Hughes, you may begin.
Thank you, and welcome everyone to the first of many National Practitioner Data Bank Guidebook presentations. We're quite pleased to join you today and to have participated in the crafting of this conference with NAMS. Let me introduce you to my colleagues who are here in the room with me. They include, well, let me introduce myself. More specifically, I'm Erna Hughes, the Director of the National Practitioner Data Bank. Joining me are Laura Burns, who's our Branch Chief for our Policy and Disputes Branch, Jason McGee, who is a Public Health Analyst. Also in the room are other colleagues of ours, Bill Burgess from the Office of General Counsel, Judy Rogers, who is our Deputy Director, Denise Flynn, our Chief in our Compliance Branch, and Elizabeth Lowry, who is a Policy Analyst in our Policy and Disputes Branch. So thank you so much for being here. I hope that a number of you that are signed in are folks that I've met in person before, so it's a pleasure to come to you and to be part of a process of being in conversation with you about our guidebook. So to give a little more boundary, if you will, or clarity on today's presentation and the guidebook itself, want to just affirm the fact that the guidebook is about, today's presentation is about explaining some policies that are contained in the guidebook and responding to some questions that were raised by NAMS. It's important to note, however, the guidebook is in its current format a combined guidance for, from the NPDB, the HIPDB, as well as added language from Section 1921. The guidebook, while 13 years in the making, did not introduce any new policy that required regulatory or statutory change. So we've got lots of ground to cover in this presentation, and because of that, we're going to run a pretty tight ship. Which means that we'll be looking at the clock closely in an attempt to get to all of your questions, and in so doing, we want to handle the questions in a particular way. We'll take questions from the audience midway through this presentation, as well as at the end of the presentation, saving about 10 to 15 minutes in total. We'll take your questions by phone, as well as the WebEx room. Since we won't be able to get to everything, or we anticipate not being able to get to everything, those questions that we can't handle in real time will gather through the chat box and group and respond to those general questions. As always, it's our practice to be available to you for individual consultation, and so I encourage you to reach out if you need to, particularly if you have a very nuanced question and you want one-to-one guidance. We're always here to provide that kind of consultation. The questions that we collect through this presentation will make the answers available to you, and those answers will be available through our public website. So following this session, we'll give you a little bit of a what's next. Here's where you can find your questions, the answers to your questions. Finally, if you have difficulty hearing, please do let us know in real time. Don't save that or one of the questions that we collect. And you can tell us any difficulty that you're having hearing us by using the icon in the top left corner of your screen. You can indicate that you'd like us to speak up. So with that said, again, I'll just say that it's a pleasure to come to you and to have my colleagues be part of this dialogue, and also just to amplify the point that we don't see this as an event, but rather an ongoing opportunity to be in conversation with you to answer your specific questions. So I'd like my colleague Laura Burns to join us.
Okay, thank you, Erna. All right, so I'm going to go ahead and get us started, and like Erna said, we will do a question and answer session in the middle of the presentation. I will be doing kind of the first half, and then Jason will be doing the second half. So we'll pause in the middle, and get to as many questions as we can before moving on. All right, so here's our overview of our presentation today. We're going to go over some of the basic clarifications and policy additions that were in this revised guidebook. And then we're going to go into investigations a little bit because that was something not only NAMS had some questions about that we think we can give you some additional clarifications, but in general we received a number of comments from the public. Then we'll go into some of NAMS specific comments. At, let's see, 2013, we put in the Federal Register a draft guidebook and allowed everyone to comment on it in the public. And NAMS submitted several well thought out comments that actually instituted some of our revisions. So we will go over those as well. And then Al Edelman, who wrote an article for Synergy, nicely outlined a lot of the issues that are relevant for NAMS, and then at the end of it, the article contained 6 additional points, and we'd like to address those as well. Okay, so as I said, we released a draft to the Federal Register in December of 2013. We received about 360 comments from 30 individuals and organizations. NAMS submitted comments on a range of issues that included renewals, temporary privileges, administrative actions, and investigations. The format was changed. We added tables, charts, FAQs, call-out boxes, and live links so that the guidebook is more user-friendly and dynamic. Right now, the guidebook is available online as a PDF, but at some point in the near future, you'll be able to access it as an HTML. And this is a screenshot of the current PDF version of the guidebook. If you were to click on any of those links to chapters, it will take you right to that location in the guidebook. So an overview here, what the new guidebook does, it blends the HipDB and NPDB to reflect new combined regulations. So the HipDB, as you all know, has been out of commission for about 2 years, and everything that was contained in the HipDB is now in the NPDB. The guidebook also adds language around Section 1921, as we didn't have policy guidance on that until this version. And we also offer policy clarification. Where things were not answered or explained, we try to draw those explanations out so that things were as clear as they could be for you when you're reporting and querying. What the new guidebook does not do, it did not make revisions that require a legislative or regulatory change. So we are still operating under the same regulations. Even though we combine the regulations, the requirements are the same. And we were unable to accept or address every recommendation, as you can imagine. However, we went over all of them. We went through every single one of those 360 comments and grouped them and addressed all of the ones that we could. And I think that ultimately it was a great experience for us to make the guidebook as relevant for you as possible. Now we'll get into some of the places where the guidebook has additions and clarifications and go over some of those things, specifically that NAMS is interested in. And then we might have, I think I have one slide or so on licensure actions that we can look at quickly, but the rest of this is all very relevant for NAMS. So first we have the eligible entities. We expanded the definition of other healthcare entity to include accountable care organizations, which is something that came under the Affordable Care Act. So if the accountable care organization credentials and privileges practitioners, it is considered to be a healthcare entity for purposes of reporting and querying, just as long as it's engaged in professional review activities through a formal review process. We also added some language around registration requirements to clarify that. DBIDs are assigned to entities when they register with the NPDB and to authorize agents that act on behalf of registered entities. Eligible entities may choose to register 2 or more departments separately under different DBIDs. However, departments with different DBIDs must query separately and cannot share query response information. So that's going to be something that hospitals will decide what works best for them, if their departments should share DBIDs and have different authorized users, or if separate DBIDs are what would be best for their business needs. Each authorized user is required to have a unique user account with a unique user ID, and entities may have multiple user accounts or user IDs for any given DBID. Subjects of reports. So we added some more comprehensive definitions, or we have more comprehensive definitions, I should say, of healthcare practitioners, providers, and suppliers, and we added examples of all three. So for one, we provided clarification that the subject of a report may be someone who is licensed, as well as someone who holds themselves out to be licensed. And another example would be some states define healthcare navigators under the Affordable Care Act to be suppliers, a healthcare supplier. The guidebook includes language around both of those. Queries. We added some language around centralized versus decentralized querying, credentialing. If a healthcare system conducts its credentialing centrally, then the healthcare system may query the NPDB once on each practitioner during the professional review process, whether that practitioner provides healthcare services in one or more locations. But again, in that instance, the CBO operating with a centralized peer review process and decision-making body should register with the NPDB as a single entity. And if the system's healthcare entities each conduct their own credentialing and each entity grants privileges to provide healthcare services only in that one facility, then each healthcare entity must query the NPDB separately on its own practitioners. So in these instances where the credentialing is done separately, sharing those query responses is prohibited. A CBO in this instance should register with the NPDB as an agent if each healthcare entity for which it works conducts its own credentialing and grants privileges as its own facility. Let's see, with delegated credentialing versus the use of an authorized agent, we went into this a little bit more. Delegated credentialing occurs when a healthcare entity gives another healthcare entity the authority to credential its healthcare practitioners. In a delegated credentialing arrangement, the healthcare entity that delegates its credentialing responsibilities is not considered part of the credentialing process and is prohibited from receiving NPDB query results. So contrast this to a healthcare entity that uses an authorized agent to query on its behalf and still retains responsibility for credentialing its practitioners. So hospitals are required to query on courtesy staff. Oh, actually, this is an additional point I'm going to do a little bit more clarifying with. So the clinical versus non-clinical privileges. Hospitals are required to query on courtesy staff who are considered part of the medical staff, even if afforded only non-clinical professional courtesies, such as the use of the medical library or continuing education facilities. If a hospital extends those practice courtesies without appointing practitioners to the medical staff, then querying would not be reported, or would not be required, I'm sorry. So the distinction here is that if you have, for instance, and this came up during our education forum for anyone who may have attended a few months back, there was a question around why would we have to query practitioners who do not have privileges and don't interact with patients if they have just sort of these courtesy privileges to use the library or the continuing education facilities. And while we understand that feedback, and the first part of that answer is just the regulations are written this way, and they require that anyone on your medical staff be queried. So hospitals have the option, if you wanted to extend courtesy, privileges is the wrong word, but if you want to extend courtesies and allow your practitioner to use facilities but not have clinical privileges, there might be a way to do that without putting them on the medical staff. But if they are on the medical staff, then you would be required to query them. And the logic of this, although we can't explicitly speak to the congressional intent, the query requirement is to allow hospitals to know about the issues a practitioner has had outside of that organization. So even if he or she is only applying to use the facilities and not interacting with patients, a hospital may still have a need to know about that practitioner's former behavior in other facilities. And remember, actions taken against practitioners that involve professional conduct are reportable. And those might be some of those legitimate reasons why you'd want to know someone who you're allowing into your facilities has, what their background is. Let's see, with reports. A couple of things around reports, we added some language around revisions, corrections, and appeals. A revision modifies a previous action but does not negate the action. If an entity changes a penalty it imposed and the original report accurately described the penalty at the time of the original report, a revision is submitted. And correction corrects an error or omission. For appeals, an appeal notifies the NPDB that the subject has appealed an adverse action with the entity taking the action. So you should notify us of an appeal that's going on. A notice of appeal is attached to an existing report, and it's submitted by reporters for the following actions: licensure, convictions, civil judgments, exclusions, and other adjudicated actions. Okay, so I have a little bit about medical malpractice here. The guidance on medical malpractice includes the definition of written claims. So to be reported, a medical malpractice payment must be the result of a written complaint or claim demanding payment for damages. And the NPDB interprets this broadly. We've always interpreted this to include any form of writing, including pre-litigation written communications. And the NPDB, not the entity, determines whether a written claim has occurred for the purposes of filing a report. An example there, so if you label it differently, would not make it a non-written claim if you affix some sort of term to it otherwise. But for the purposes of reporting to the data bank, if a written claim exists or written demand for payment, then you would move to the other requirements to see if that payment is reportable. With identifying practitioners, we did add some guidance around this so that if a practitioner is not named in the actual, as a defendant in the suit, but is described sufficiently or identified in the narrative of the written complaint or claim, a payment would be reportable if that practitioner is also named or identified or described in the settlement or final judgment, and that when the payment is made on behalf of the named, identified, or described practitioner. So just because a practitioner is not named as a defendant, if they are identified inside of the written complaint or claim, then the payment may still be reportable if those other factors are met, that the payment is made on behalf of the practitioner and they are named and identified in the settlement or final judgment. Okay, investigations. We're going to go into this with some more detail in a minute, but I'm just going to give you sort of the overview. Investigations alone should not be reported, but a surrender of clinical privileges or failure to renew while under investigation or to avoid an investigation must be reported. The term investigation is not controlled by an entity's bylaws. However, that's just to indicate that other factors may be considered. The guidebook says that bylaws and hospital documents should be used to determine if an investigation has begun, and we expect to defer to hospitals on this. Largely, we expect hospitals to apply our guidelines logically to determine for themselves if an investigation has occurred. But like I said, we will not be limited necessarily to those bylaws if there is evidence otherwise that an investigation has occurred. And so we'll get into this a little bit more, but for right now, some of the factors on the screen in front of you on this PowerPoint slide, these are the things that you would consider as a hospital when determining whether or not the investigation has begun. Is it a routine review, or is it focused on a particular practitioner for a particular conduct concern? Routine reviews are not considered an investigation. However, the more focused inquiry could indicate that an investigation has begun. An investigation should precede a professional review action. And we'll discuss this a little bit further in factors that you could consider while you're determining whether or not that this is something that leads to a professional review action. And the investigation is ongoing until the decision-making authority takes its final action. An investigation doesn't just end because someone resigns. It ends when the decision-making body closes it or takes a final action. So quickly, we'll go through these. Let's see, professional society review actions. We did a little bit more clarifying which ones of those would be reportable. Professional review actions that go through a formal peer review process in which the society determines that a member's professional competence or conduct adversely affects or could adversely affect the health or welfare of a patient. Those are the actions that must be reported to the NPDB. And with other adjudicated actions, federal and state agencies such as Medicaid, state Medicaid fraud control units, state agencies administering or supervising the administration of a state health care program, and health plans must report other adjudicated actions or decisions against healthcare practitioners, providers, and suppliers. The hallmark of an adjudicated action is the availability of due process. This definition excludes clinical privileging actions and contract terminations unrelated to healthcare fraud, abuse, or quality of care. Other adjudicated actions or decisions taken in conjunction with clinical privileges actions. For those, if an entity takes both a clinical privileges action and another adjudicated action or decision, the entity must report them separately. Proctoring. We'll go into this a little bit more when Jason goes over some of your questions and issues. This came up as a comment that NAMS had. So, overview of this, though, we did provide clarity that if a proctor is required to give approval, that's reportable. If a proctor is required to be present for the procedure to go forward, that's reportable. Where it becomes unreportable or non-reportable is in the case where a procedure could go forward without the proctor's approval or presence. And so these are just a couple things about licensure and certification actions. They don't necessarily have relevance to NAMS concerns, but they are an area of the guidebook that receives some attention in our revision. So I will briefly go over some of those. The administrative fines, with that, we looked at administrative fines and money penalties that are formal or official actions against healthcare practitioners, providers, or suppliers, and those are reportable. Fines that are considered administrative or technical in nature must be reported to the NPDB only if they meet the NPDB definition of negative actions or findings. And they must be connected to the delivery of healthcare services and taken in conjunction with other adverse licensure or certification actions. And they must be publicly available information. Requirements for state licensure actions are not limited to final actions. Reportable are summary and emergency suspensions, an agreement to refrain from practicing pending an investigation. And a licensure, for state actions, a licensure action imposed with a stay should not be reported to the NPDB as long as the entire action is stayed. When only part of the action is stayed, the part that is not stayed must be reported. Denials. Denials on initial and renewal applications, cases in which threshold criteria are not met should not be reported, but denials of initial or renewal applications are reported if they are adverse actions resulting from formal proceedings. And withdrawals of initial versus renewal applications. Withdrawal of renewal application for licensure is reportable. An applicant's withdrawal for any reason of the initial application for licensure is not reportable. And this is going to generally be the case for hospitals as well, that the withdrawal of initial application is generally not reportable, even if the applicant is under investigation. The NPDB, let's see, and the last one here, voluntary surrenders. The voluntary relinquishment of a practitioner's license for personal reasons such as retirement or illness is not reportable unless the surrender of the license happens while practitioner is under investigation. So a difference with licensure and with hospital, if you withdraw a renewal application or surrender while under investigation in the hospital setting, the practitioner does not need to be aware that the investigation is going on for that withdrawal to be reportable, or that surrender. All right, So we're going to go into investigations a little bit, and then we'll have the chance for some questions. Just a few points about investigations before we get into the NAM-specific comments and questions. We understand the concerns expressed by the medical community, and this is not an expansion of our old policy, but we do hope to address those concerns with this conversation and with our guidance in general. As we say in the guidebook, and as I think I said earlier, bylaws and hospital documents are used to determine if an investigation has begun, and we do expect to defer to hospitals on this. We expect that hospitals will apply these guidelines logically and determine for themselves if an investigation has begun. And the statement in the guidebook that the NPDB retains the right to be the ultimate arbiter is to respond to the fact that hospitals may have different ways of approaching investigations and gives the hospitals flexibility. So in general, the questions that we sort of received were around when does a routine peer review end and an investigation begin for purposes of reporting a resignation or withdrawal while under investigation. So generally, we can look to the slide for this. You would look to see what distinguishes this particular inquiry from routine review that's instituted for continued learning and professional growth. Is it focused on a practitioner in particular? Does it concern the professional competence or professional conduct of the practitioner in question? So here's an example. It's not, well, when you're looking at this, are you looking at a specific concern, or are you looking generically, you have reason to believe that maybe this practitioner requires additional monitoring? That might be a little bit different than you have a very specific concern with their ability to provide X, Y, or Z services that you are looking into more in depth. And we'll get into that a little bit more as well, but this should also generally be the precursor to a professional review action. So to answer that question, you might look at the hospital bylaws. You might look at practice standards. How often does this type of review result in further action? If there's a performance agreement, you could look to the language of that performance agreement. Does it say anything about future disciplinary actions that would result from not meeting the elements of this performance agreement? We got a lot of comments on the guidebook about our use of OPPE and FPPEs in our examples. We did remove that language. We can't say across the board that an FPPE will never be the start of an investigation. A good example that we were given from another interested party was that, what if an FPPE is extended? At the point where an FPPE is put in place, there's an argument to be made that that's still routine review and not the start of an investigation. But at the point where it's extended, this might be where you deviate from that routine review and where an investigation is actually started. So you would look at the language in that FPPE to see if it's non-routine. Is it focused on competence? Why was this FPPE extended? Was it because there were a certain number of things that had to be completed as a part of the FPPE that weren't completed in a certain amount of time? That might not be a focus on conduct, whereas an FPPE might be extended because there were actual concerns with how a practitioner was performing this specific duty. And then generally when you're thinking about this, whether or not it's a precursor to professional review action, you could consider, you might not always be able to predict at the initial inquiry where it will lead, but you might have enough information to get an idea of sort of the seriousness or the potential extensiveness of the inquiry based on, your experience with this type of concern or your knowledge that you have about this particular incident. So with those things in mind, the hospital should be able to make reasonable decisions as to whether or not an investigation has begun. So just to summarize, it begins with an inquiry. We've gone over this and the issues around how to determine if an investigation has begun. We will defer to hospitals and your judgment, but we will ask that it's backed with documentation and bylaws. The investigation does not end until the entity's decision-making authority takes final action or formally closes. The use of the word expansive in our guidebook's definition of investigation drew a few comments, but really the word expansive was used to refer to the point that an investigation only ends when the final decision is made, or when the decision-making body, the hospital, when they close the investigation. It means that an investigation doesn't just end when a practitioner under investigation resigns his or her privileges. And I've said this a few times, but I'll just keep emphasizing it. We will typically defer to the hospital to make the decision as to whether an investigation has occurred, but we will use our discretion when we believe an investigation, if we have reason to believe an investigation has occurred. So here's just sort of an example. Generally, if the hospital is reasonable in defining the beginning of an investigation, we defer to them. For example, it's reasonable to us that a hospital begin an inquiry at the time of an MEC referral. However, if that's written into the hospital's bylaws and that hospital also has a peer review process prior to the MEC referral that includes multiple layers of focused assessment based on competency concerns of a practitioner, then that would be an example where the NPDB might come in and ask you to defend your definition of an investigation. Okay, well, we'll move on in the interest of time, and if we have, I think we will have time at the end of this session as well for more questions.
Okay, so we received a letter dated January 30th, 2014 from the President of NAMS, which addressed changes that your organization wanted to see made to the draft guidebook. Those suggested changes are what we will go over now. The page numbers that I will reference refer to the current page numbers after editing took place, as opposed to the page numbers referenced in the NAMS letter. Sorry. Okay. Starting with what is now page E2 of the guidebook, NAMS recommended that the following sentence be rephrased and limited in its reference to reporting actions based on the NPDB's reporting requirements. Quote, an action must be reported to the NPDB based on whether it satisfies NPDB reporting requirements and not based on the name affixed to the action by a reporting entity, end quote. We added examples that clarify what we mean in the sentence. To quote the guidebook, quote, for example, whether an administrative fine is reportable to the NPDB depends upon whether the fine meets NPDB reporting requirements, not on the name affixed to the fine. So, it does not matter much what an action is called. What matters is the character of the action in terms of its effects and how it is carried out. Moving on to page E31 of the guidebook, NAMS stated that as to our example of an administrative action, it would be very unusual for a physician's board certification status to be revoked. NAMS recommended that we replace that example of a revoked board certification. We revised the guidebook to say that the physician's board certification expires instead. Again, on page E31 and a bit on page E32, NAMS stated that probation is not a reportable action when taken by a hospital or other healthcare entity, but that it is a reportable action in the context of state licensure. Therefore, NAMS concluded, the end of a probationary period at a hospital should not necessitate a revision to action report. Therefore, we removed reference to probation and replaced that with a consultation period being shortened and requiring a revision to action report. To the point that a probationary period is not reportable in a hospital context, that is true if the probation does not result from a professional review activity and does not restrict privileges. To the extent that a probation does result from a professional review activity and requires monitoring for longer than 30 days, then it would probably fall on the line of being reportable. With regard to page E35, NAMS wanted it to be clear that when a physician or dentist has an agreement for temporary clinical privileges with a party granting those privileges, that there will not be a reporting requirement for failure to renew privileges while under investigation. The guidebook is now clear on this point. The guidebook reads when, quote, both the physician or dentist and the privileging party agree that the privileges are temporary, unquote, there is no reporting obligation for a failure to renew privileges while under investigation. Moving on to page E37, NAMS wished for us to clarify whether a proctor's reporting on an individual's performance is a reportable professional review action. It is not. If a proctor does not have to be present for or approve a procedure, a report is not required. If a proctor does have to be present for a practitioner to perform procedures, this would constitute a restriction of privileges. This is now made especially clear on page E37. So moving on to page E45, NAMS felt that an example of a summary suspension being imposed on a physician due to failure to respond to an emergency department call was not a good example of when a summary suspension is imposed because of the unlikelihood of imminent danger to others. Therefore, we changed the example to a chief of surgery who was prone to violent outbursts, a situation where there is potentially imminent danger to others, possibly leading to a summary suspension. This is a great example of when your experience in the field has a direct impact on the guidebook. Okay, so now we'll turn to additional questions posed in a Synergy article by one of your contributing writers. We reviewed the article by attorney Alan Edelman titled, "The New National Practitioner Guidebook is More Necessarily Better." There were 6 lingering questions posed at the end of his article that we would like to address here. The first question is whether an agreement not to exercise privileges during an investigation without actually surrendering the privileges is a resignation while under investigation. In answer to this question, so long as privileges are restricted, then yes, such an agreement not to exercise privileges during an investigation would qualify as a resignation while under investigation. The language in the regulations is that, quote, acceptance of the surrender of clinical privileges or any restriction of such privileges while under investigation, unquote, is reportable. We consider an agreement not to exercise privileges a restriction of privileges. Any loss of clinical privileges while under investigation is to be considered a surrender. A resignation of privileges while under investigation, a restriction of privileges while under investigation, any loss or restriction, temporary or otherwise, is considered a surrender of privileges and must be reported. Please note that the statute only says acceptance of the surrender of, sorry, my mistake. Moving on to the second question. As to the second question, a requirement that a surgeon operate only with a qualified first assistant might be a restriction depending on the circumstances. The questions we would ask include, did this requirement result from a professional review activity? Is it a result of a concern about professional competence or conduct? Is this standard for everyone or standard for new surgeons? Is the surgeon prohibited from operating unless the first assistant is there? Or is the restriction more that the surgeon complete a number of surgeries with a qualified first assistant over a period of time? Is a surgeon allowed to proceed on surgeries without the assistant? It also has to be asked whether the qualified first assistant has to be in place for more than 30 days. The third lingering question is whether resignation while subject to a, quote, quality improvement plan, unquote, counts as a resignation while under investigation. An example of a quality improvement plan might be a limit on the number of patients the physician could have in the hospital at any point in time, or a requirement that all surgical cases must be discussed with the department chair in advance. To answer this question, because it sounds like the quality improvement plan restricts the clinical privileges of a practitioner, to the extent that this restriction is the result of a professional review action, concerns the professional competence or conduct of the practitioner, and is in place longer than 30 days, the quality improvement plan in and of itself may be reportable. If it doesn't meet these requirements, the quality improvement plan could be considered an investigation, so long as it meets the other requirements for an investigation. Does this lead to professional review action? Is it focused on one practitioner for competency concerns? Speaking of the quality improvement plan. If the hospital determines that this meets the requirements of an investigation, then resignation while under a quality improvement plan would be reportable. The fourth question has two parts. It is asked whether a report is required when the following is true. A lapse of clinical privileges at the end of a 2-year appointment occurs after the medical executive committee recommends that the physician not be reappointed, and the physician's current 2-year appointment ends before a hearing can be held and before final action is taken by the hospital's governing body. A non-renewal while under investigation is reportable to the NPDB. So this lapse would in effect be a non-renewal. The investigation that's going on at the time of that the renewal lapses would then trigger reportable resignation privileges while under investigation. With regard to the fifth question as to whether taking a leave of absence while under investigation qualifies as a resignation of privileges, so long as a leave of absence restricts the privileges, then yes, it's reportable. The language in the regulations is that acceptance of the surrender of clinical privileges or any restriction of such privileges while under investigation requires a report. To the extent that a leave of absence restricts a practitioner's ability to exercise privileges, it thus is considered a surrender. Any loss of clinical privileges while under investigation is considered to be a surrender. A resignation of privileges while under investigation, a restriction of privileges while under investigation, any loss or restriction, temporary or otherwise, is considered a surrender of privileges and must be reported. Concerning the sixth and last question of the article, we would ask several questions to determine whether an application for reappointment has become an investigation if a credentials committee requests additional information in light of medical malpractice cases. We would ask, how routine is it to ask for additional information? Is it something that's done automatically when there's a certain number of malpractice payments? Or is it due to the specific nature of one of the payments that causes concern of a practitioner's competency or conduct? So that ends our going over the questions. I will turn it over to my branch chief.
Okay. We will, with that, go into our evaluation. So if you would be so kind to take a few minutes to answer the following questions, we would appreciate that. And if you have additional questions and you want to throw them into the submit a question box, feel free to, and we'll put them with the others and compile our responses for you. And so with that, I'd like to say thank you for everyone who attended, and if anyone has any closing comments, we will do the evaluations and complete today's webinar. Thank you.